So let's now turn to the question of cyberstalking. And to set up this discussion, I want to show you a brief video clip of ways in which someone could be engaged in cyberstalking. You'll notice in this clip someone named Tim Ryan. He's a former FBI agent, used to run the FBI's cyber unit in Newark. He's a friend of mine. And he happens to appear in this video. So I'll show you this video, and then we'll come back and talk about it. So welcome back, and it should be no surprise to all of us that given the extent of all of our online lives, if someone wants to track us down and someone wants to harass us online, they probably can do it. Now, Tim Ryan in that video, being the good consultant that he is trying to tell us to keep various things segregated in our online lives. As we talked a little bit in class last week about this, that can be really difficult to do. In some ways, maybe it can be impractical to do, and in some ways, maybe our social norms suggest that nowadays suggest that we don't need to do it to such an extent, but we do need to be aware that someone could come after us. And these kinds of things do happen, and they do happen regularly, and you see that in the cases that we've looked at. You can also see that in some news reports, and I'll put some links up on the website to some other news reports that show you some other examples, if you want to watch them, of cyber bullying, cyber harassment, cyber stalking. So how does the law respond to this? We have looked in some detail now at the Computer Fraud and Abuse Act, and you should notice that the Computer Fraud and Abuse Act doesn't really deal with what we're calling cyber stalking. Now, it's possible that some portions of the Computer Fraud and Abuse Act could be implicated by some of the kinds of activities that we call cyber stalking. So certainly if someone hacks into someone else's computer in order to get information or manipulate information to engage in harassment, that also could be a violation of the Computer Fraud and Abuse Act. Or the extortion provision of the CFAA could be implicated, although it's not really the typical case. That's typically for some kind of hold up for financial gain. Fraud aspects of the CFAA could be implicated as well, but generally the CFAA is not designed to go after the kinds of harassment and stalking and threats that we're trying to address in this lecture and next week as well. So we're going to talk a little bit about federal law today, and we'll talk a little bit more about state law next week. So the federal statutes that exist, there are a number of statutes that beyond the CFAA that potentially could be applied to the kind of conduct that we're talking about today. One of them is 47 U.S.C. 223, which is titled Obscene or Harassing Telephone Calls. And as you might imagine, it was originally created in the telephone age, but it's broad enough because it talks about the use of a telecommunications device to cover some of these kinds of activities. So this is one possibility, and you'll see the kinds of transmissions that could be implicated. A proposal image communication which is obscene or child pornography with the intent to annoy, abuse, threaten, or harass. Now you should be thinking, as you look at these statutes, both this week and next week, we'll talk about it a little bit this week and some more next week, how broad can this go and still be constitutional? Think about, for example, the use of any telecommunications device to annoy somebody. How often does that happen, let's say, on Facebook? If I put a post up, a sarcastic post up about Donald Trump, because I know my brother-in-law likes Donald Trump, and I know this will annoy him, am I violating federal law? I suppose in one sense technically I could be, but I highly doubt that ought to be considered a violation of federal law. So think about, and obviously that kind of conduct isn't likely to get prosecuted, But think about where the lines are. And it can be hard, I think, to draw these lines and to figure out where we ought to draw them. Another statute that often gets applied in these kinds of cases is 18 U.S.C. 875C. And again, this is a statute that really relates originally to kind of telephone days, and you'll see that it's kind of revolves around kidnapping, threat of injury, that sort of thing. But it also applies because it's, again, any transmission in interstate commerce of any communication. It also can apply, this threat statute also can apply online. So we'll look at a few cases that deal with that. The primary statute, in one sense, today now is what's formally titled the Violence Against Women Act, but also has these provisions that are called the Federal Cyberstalking Law, and it's found in 18 U.S.C. 2261, capital A. So in subsection 2 of capital A here, you see this provision, and I'm showing you this language, and then I'm going to show you how this statute was amended in 2006 specifically to address cyber issues. And then I'll show you again how the statute was amended in 2013 to try and further address cyber issues. So you'll see here intent to kill, injure, or harass, or intent to place under surveillance with the intent to kill, injure, harass, or intimidate, or with the intent to place a person in another state in reasonable fear of the death of, serious bodily injury to that person or a member of their immediate family, spouse, or intimate partner using the mail, or any facility of interstate or foreign commerce, or any interactive computer service. So you see that those definitions that include interactive computer service or any facility of interstate or foreign commerce, which certainly most ISPs are going to be engaging in these kind of conducts, can be a violation of this statute. Notice the requirement that the course of conduct actually cause substantial emotional distress to that person in reasonable fear of death or serious bodily injury to that person or an immediate family member, and so on. So there is both an intent requirement and an effect requirement. An intent to injure, kill, harass, or place under surveillance with injure, kill, harass, and the effect of causing substantial emotional distress, even if the person isn't actually, killed or physically injured. Now, where was this statute amended in 2006? It was first amended to include this word harass. It had only included, it was sort of a traditional stalking statute, and it was being tried to brought into the digital age to include things beyond physical stalking to kill somebody. So harassment was included there, or the intent simply to cause substantial emotional distress. So the idea here is this kind of bullying and harassment online. And the interactive computer service was added. So to try and be clear that the cyber aspect of this is specifically covered, and the fact that it would cause substantial emotional distress, not simply other kinds of injury. So all these things were added to make this a statute that is dealing specifically with cyber stalking. Now let's talk a little bit about the 2013 amendments, and I'm going to pull these up on the screen from Westlaw so that we can talk about those.
So here is the current version of the statute, which includes the 2013 amendments. And if you look at subsection 2, you'll see some changes. The first set of changes involves the kinds of facilities that if one uses them would trigger the statute. So uses the mail, any interactive computer service, we've seen that before, and or any electronic communication service or electronic communication system of interstate commerce. And so these two categories, I think, are intended to capture email, social media messaging platforms, and things of that nature. Probably interactive computer service, facility of interstate or foreign commerce would have included those already, but these things are added to make clear that those sorts of uses are covered. Notice then in subsections A and B, the fear of death or serious bodily injury is then broken out from the substantial emotional distress. And notice what could be potentially a significant change in sub B there, which is causes, attempts to cause, or would be reasonably expected to cause substantial emotional distress. Now, in a moment, we'll talk about the Conlon case, which is one case upholding the constitutionality of this provision against a claim that it unduly that it's overly vague and that it unduly impinges on free speech. And there are a number of challenges like that. There's one in a district court in Maryland that in fact found the statute, the 2006 version of the statute, unconstitutional. But the Conlon case upholds the constitutionality of the statute. But notice the reasoning, and a key piece of the reasoning was that the court said it's not only an intent to speak in a certain way that might be offensive, but also the effect of causing substantial emotional distress. When you add the effect to the intent, the Conlon court said, you can conclude that the statute is constitutional. Now, I'm not sure that reasoning is sound, at least under this version of the statute, because in subsection B, it appears to me that it would not necessarily have to have the effect. It simply could be reasonably expected to cause substantial emotional distress, even if the speech doesn't actually cause substantial emotional distress. So there perhaps is a lingering question about the constitutionality of this statute, and I think that's one of the kind of underlying legal and policy issues you ought to be thinking about as we look at some of these cases that deal with cyberstalking and harassment, and then next week when we look at bullying and other similar statutes, we have a difficulty saying that speech that is offensive should be illegal simply because it's offensive. Because after all, the First Amendment, if it protects anything, protects speech that some people find offensive. And yet, the law wants to have some limits when it comes to these activities that we would call stalking or perhaps bullying and harassment. So keep those things in mind. And now we'll take a look at the Conlon case and some other cases.